Look at those 700 delegates who are now uncommitted and get into the action. And I do believe that all the delegates are committed only for the first round. And so you can actually fashion the process that's already in place to make it a mini primary. And I would support that. Absolutely. Ooh. We can't close that down and we should open up everything for the general election. And I think that Kamala Harris would acquit herself very well in that kind of a process, but then it would be fair to everybody.
Mm-hmm. So this is new audio from James Clyburn, who's really the kingmaker of the Democrat Party. And I was saying this last week, the only reason Joe Biden's president of the United States because James Clyburn saved him during the primary and delivered South Carolina for him. And there was a deal that was made there. You put Kamala Harris on your ticket, then I'm going to make sure I deliver, a crucial demographic voting block for you. And that's exactly what Clyburn did. And then Clyburn came out yesterday evening and said, no replacement unless it's Kamala Harris. Now today he's like, yeah, we could have a mini primary, because I think that he realizes that having someone as unlikable as Kamala Harris as the lead on the ticket, that's an insurmountable odd. She was in last place in the primary back in 2020, and she's never been popular. She can't raise money either, which is incredibly significant when you're going into this much of a deficit if you switch it out like this in the 11th inning. Welcome back to the program. Dana Loesch with you. I have to say, before we bring on my next guest, I'm laughing my head off at the New York Times. So mad. They went after Trump with this stupid lawsuit, the state of New York. Now the New York Times is like, can you believe that Donald Trump hasn't announced a VP yet? And they're mad because he's not giving them anything to write about other than Biden. And they're like, Donald J. Trump hasn't announced a VP candidate. Like, they call him by his middle name. They're so angry. They don't have anything else. And in the meantime, all of this is happening. And then I started laughing harder because Andrew Bailey comes out. It's another day that ends in Y. And he's like, whose backside can I kick today legally? Let's see. You, New York, I'm filing a suit against you. So it's filed at the Supreme Court under Article 2, Section 2 of the Constitution because of the insane way that New York handled that lawsuit. And Andrew Bailey, Attorney General of my home state, beautiful state of Missouri, joins us now on this Independence Day Eve. And sir, it's a pleasure to have you. I want to get into this lawsuit because you and I are very much on the same page with New York. And I love the way that you're handling this. But I have got to get your opinion on everything that's happened in the past 48 hours with the Democrat Party.
Oh my gosh, they're in an infinitely regressive death spiral. I mean, it's absolutely, it would be comedic if it wasn't injecting poison into the Democratic election process and depriving Missourians and citizens of every state the right to actually engage in a meaningful way in a national election in the heat of a campaign in the most consequential presidential election in this nation's history. Let's start with this idea that Biden shouldn't be on the ticket. The rest of us knew that months ago. They should have pulled him before these states had their primaries and their caucuses. Now they want to play a shell game. Again, that undermines the integrity of the election process. Why did we have primaries and caucuses if they're going to play a shell game and swap somebody out for an unknown and then deny us of our meaningful voice? But then you see Joe Biden reacting to the immunity decision from the United States Supreme Court. And has anyone told this guy that he probably missed the early bird special and they're out of tapioca pudding because he was out doing a press conference at 5 p.m. And what a press conference it was. 4 minutes and 59 seconds. No questions from the media. This guy should be popping champagne. Right, this means that he can't be prosecuted for aiding and abetting in human trafficking and fentanyl distribution from the chaos at our southern border. This benefits him. I mean, this is absolute insanity. And I absolutely think that he should not be the president of the United States, but the Democrats shouldn't be allowed to swap him out now. That's totally unfair.
Yeah, that's a really good point. And that's what Clyburn was talking about. Do a mini primary, because if they do what you're talking about, they're cutting all the delegates out of the equation. And then it's just, the power players within the Democrat Party that are deciding who the substitute's going to be. And that scares me too, because it's all the people who have been leading these witch hunts this entire time. Let me segue into the New York case, because Missouri v. New York lawsuit filed today. And this has to do with the jurisdiction of this case. So for the people who, because I know that there's so many things Democrats have been throwing at the former president, for the people who may need a recap, this is that suit where they tried to straw man up something to charge him with to take it out of state court and make it a federal court issue. And that's what you're challenging.
Yeah, that's right. Look, this lawfare against President Trump, again, it's undermining the integrity of the democratic process. They're supposed to be the sacred guardians of our democracy, and yet what they're doing is essentially denying people the ability to engage in a presidential election. Missouri is a sovereign state with a sovereign interest in participating in a national election on equal footing with every other state, and we can't let a rogue prosecutor and a collusive judiciary in the state of New York and their communist witch hunt persecution. It's not even a prosecution, it's a persecution of President Trump that takes him off the campaign trail and silences him. That's depriving Missourians and anybody else access to a presidential candidate in the heat of a campaign. It's unconstitutional to allow one state to deprive other states the ability to participate in a meaningful way in that election. That's why we filed suit. And you're right. Article 3, Section 2 of the United States Constitution gives original jurisdiction to the Supreme Court. It's Missouri v. New York. Game on.
We're talking with Missouri Attorney General Andrew Bailey. This headline that came out, Real Clear Politics had it, and it was former Atlanta Mayor Keisha Lance Bottoms, now a senior advisor to the Biden campaign, told MSNBC that, you know, these newspapers that are talking accurately about everything happening with the Biden campaign, that they are exerting undue influence, was the phrase she used. She's accusing them of election interference. Now, that sounds wild to me, especially considering what happened in New York with this case. How is that not election interference? How is the gag order not interference?
Yeah, you're right, Dana. Though using the judicial process to violate President Trump's constitutional rights and violate our right to hear from him, using that legal process is in fact election interference. Newspapers reporting, even if I disagree with the reporting they're doing, is protected by the First Amendment. These people hate free speech, and they want to destroy it in the name of silencing any political opposition. And it starts with President Trump and the gag order. Now it's going to newspapers, which I don't have any love for the legacy media, but I'll tell you this much, it's dark days in our republic. And shame on the media for legitimizing this lawfare and for not covering the fact that large swaths of this country feel left behind, because they put the official imprimatur on this sham judicial process and again deprived us of access to a presidential candidate. He can't be out campaigning if he's tethered to a New York courtroom and potentially sentenced to prison, and he certainly hasn't been allowed to speak on these issues. That's core political speech that he would be giving to his constituents. We have a right to hear from him.
Right.
So that is absolutely using the legal process to poison our democratic process and interfere in this election. We're not going to stand for it. We're going to assert our sovereign interests and our rights here in Missouri.
We're talking with Missouri Attorney General Andrew Bailey. I wanted to ask you, too, also about this Second Amendment issue regarding the Department of Commerce and them limiting the number of firearms that Americans can export, et cetera. Because we just had, the Chevron decision, this from the Supreme Court, essentially, gutting the overreach of this unelected bureaucratic administrative state. So how would that impact this with the Department of Commerce?
Well, we put a marker down. This is just a right to sue. Essentially, we sent a note to the Department of Commerce. Like, first of all, whoever gave them the authority to limit our constitutional right to keep and bear arms. And what they've done is propose a rule through the Bureau of Industry Security. I've never even heard of this agency. It's some obscure niche agency. But they've promulgated a rule that would amend a federal statute to thereby limit the number of firearms that both individuals and manufacturers can export. This is the government manipulating the marketplace to try to drive down sales, drive down profits, drive down investments into these companies to try to dissuade people from trading and buying and selling firearms. It's an attack on the Second Amendment right to keep and bear arms. They lost in the head-to-head battle on the individual right to keep and bear arms when the United States Supreme Court handed down its decisions. So now they're trying an end run around to try to destroy the marketplace for firearms, but it's still an attack on the Second Amendment. We're not going to stand for it. And I'll tell you, you're absolutely right. Chevron being overruled is a huge win for our Constitution. And what it means is that federal agencies can't amend statutes. Only Congress can do it. This reinvigorates the separation of powers doctrine that is inherent in our Constitution and is intended to maximize our freedoms and liberties.
I think that was such an important decision, too, as well. Talking with, I think probably maybe of this term, talking with Missouri Attorney General Andrew Bailey on the social media entity, because you were at the tip of the spear on this, Missouri filing suit and fighting the Biden administration over this suppression. Did that decision, maybe there's something that I missed. I don't know. It really kind of shocked me because it felt like to me, and tell me if I'm wrong on this, it felt like to me that if the government uses a third-party agency, then it's not tyranny. If they're going through a social media company, then it's not censorship. That's how I interpreted this.
Well, Dana, I'll tell you, the headlines and the lamestream media are 180 degrees wrong on this issue. And I've seen this before. The knee-jerk reaction from the mainstream media is to say, oh, well, the Supreme Court sides with Biden. And like, no. If you dig deeper and read what the opinion actually says, I think the opposite is true. First of all, yeah, I would prefer there be a preliminary injunction in place. But what the court said was that there was absolutely government censorship going on big tech social media platforms in 2020 and 2021, and that it's unconstitutional. All they said was you need to go back down to the trial court and determine whether or not that censorship is still ongoing beyond the year 2021 to the present. Well, of course it is. We know it is because we see it every day when people are deplatformed, shadow banned, de-emphasized, or straight up booted off social media. We have broad tools of discovery now that we're back down at the trial court level. And we're going to use those tools to continue to root out the vast censorship enterprise. The fight for the First Amendment goes on.
Because this was, and if for those who didn't know, General Bailey was like right there leading the fight on all of this with this case, with the Biden administration and the federal government suppressing whether it was the laptop story or I remember whatever it was, anything that contradicted the narrative coming out from the federal government in this administration. And they were talking about standing, which I thought, and I think that was something that Barrett had maybe mentioned in her opinion, because now there were so many decisions. I know at this point now that everything's kind of running together, but I thought, well, that's what AGs do. They represent the people. If anybody has a standing, it would be that route.
Yeah, I think you're right. Look, I mean, really the problem here was traceability and being able to show the harm is ongoing to today. That evidence is out there. We'll get it. Show me one example in history where the government has ever trampled on people's rights, expanded, and then contracted of its own free will. That doesn't happen. Somebody has to force it. That's what this lawsuit is about. Yeah. I think it's a fair legal question, though. Should states have a different standing analysis when we're bringing suits on behalf of the entire population of our state? I think that's a fair legal debate and one we're going to explore going forward.
That's fascinating. Yeah. And I think you're the only person who's brought that up. And I would love to see discussion on that. Missouri Attorney General Andrew Bailey, God bless you, my friend. I mean, you're just embodying everything that Independence Day stands for and going out and fighting the good fight on behalf of Americans. And we are grateful, not just Missourians, but everybody. And we're thankful.
Thank you, Dana. Happy Freedom Day.
Happy Freedom Day. Thank you, sir.